Committee substitute for Senate Bill 344, a bill to be entitled an act relating to justifiable use or threatened use of defensive force.
Senator of the 7th District, Senator Bradley, you recognized on your bill.
Thank you, Mr. President. Senators, this bill shifts the burden of proof from the defendant to the prosecution in justifiable use of force pretrial immunity hearings.
Is there debate on the bill? Is there debate? Is there debate? Senator Smith, you recognized in debate. Okay. Senator Bullard, you're recognized in debate.
Thank you, Mr. President. And Senator Bradley, as we get into the legal minutia, I'm sure there's going to be coming via debate. I'm a school teacher, right? And I understand that the shortest distance between 2 points is a straight line. So I'm going to get straight to the point. Back on February 26, 2012, Florida lost someone who would be a sophomore in college had he lived on the streets of Sanford. We saw a trial litigated in which stand your ground was again thrust into the forefront. I can't support any legislation that would open that statute because I have the distinct honor of representing one of the communities in which Trayvon Martin grew up in. So I'd be remiss if I didn't invoke his name in the presence of yet another statutory hit to a law that I still find very much unjust. And when we talk about the shifting of burden from the defendant onto the state, all I can do is think about how that trial played out and what I felt like when that jury verdict came down, and the idea that under current existing law, we have somebody who killed a 17-year-old who gets to walk the streets. And now, under this particular bill, that would have become that much more difficult. For those reasons, the same reasons that compelled me to wear a hood on the floor of the Florida House back in 2012, for those reasons, the same ones that asked me to fight time and time again for Tracy Martin, Sabrina Fulton, in honor of their son, I have to stand here in adamant opposition to any rehashing of the Stand Your Ground law. And for that reason, I oppose the bill.
We're in debate. Further debate. Is there further debate? Senator Joyner in debate.
Thank you, Mr. President. On this Stand Your Ground issue, a lot of attention has been paid to the people allegedly exercising self-defense. But I cannot forget some of the victims in these cases, because this bill will likely stop some cases before all the facts ever come to light and before we ever know if the defendant was really justified in fact. Studies by well-respected groups and organizations such as the American Bar Association, the Urban Institute, a law professor from the University of Florida, and the Tampa Bay Times found that the decision on whether someone is justified under this law varies widely depending on the color of the victim. These victims are too often the innocent children, spouses, and loved ones of people like me and my family. A wide disparity in the enforcement under this law has already been demonstrated. Simply put, someone who kills a black person is more likely to be found justified than someone who kills a black person. In fact, the ABA found that a white shooter who kills a black victim is 350% more likely to be found justified in the use of deadly force than if the victim was white. The University of Florida professor Darren Hutchinson stated it plainly. It's easier for white suspects to raise a stand your ground defense if the victims are black, and conversely, harder for black suspects when the victim is white. Recent events have shown us how important it is to allow time for a proper investigation and airing of evidence at trial. Not only does this law already provide immunity from prosecution, including arrest, But this bill further enhances the risk that a killer will be able to evade justice and never properly face the full investigation on trial, because it potentially stops an investigation cold after the last man standing tells his side of the story. The dead do not have the opportunity to rebut the tale told by the survivor. In cases where there are no witnesses, this bill stacks the deck against justice for the dead, and I cannot support it.
Further in debate? Further in debate? Senator Simmons, you're recognized.
Thank you, Mr. President, and I rise to correct the statements that I've heard made about stand your ground. In 2005, when I was in the House of Representatives and chaired the Judiciary Committee, I had the opportunity to have the drafting of the stand your ground law. As a matter of fact, what happened is that when Representative Baxley came to me and said that that there was a need to clarify the obligations of people in the state of Florida when and the rights of the people in the state of Florida when they've been attacked by somebody else, that I sat down and began drafting the what is now known as the Stand Your Ground law, and that was adopted that year, and then it actually went all across the United States, even was adopted, I believe, in certain foreign countries. The whole idea is that it makes good sense. But I tell you what doesn't make good sense is standing up and suggesting that it's not what it is. You see, we have in the state of Florida self-defense, and it's been around in a civilized society for thousands of years. There's nothing wrong with self-defense, but I'll tell you what is wrong is the way it was in the state of Florida prior to 2005, because Florida was one of the minority of jurisdictions that said that if someone came to you and put a knife to your neck and you were standing in a parking lot, that Florida said you had to run. You had to turn and run if you had any reasonable opportunity to do so. So if you were a woman who was in a parking lot and a criminal came to you and put a knife to your neck, you didn't have the opportunity of grabbing his arm or his wrist and trying to stop him. You were obligated to turn and run. Now, I believe that's not a very good policy. I believe that the person who has a knife to his or her neck, when they're standing in a place they have a right to be, shouldn't be second-guessed by our prosecutors, second-guessed, and in fact, required to turn and try to run. That they have the opportunity in that split second that is going to decide whether or not they're going to live or die, to be able to defend themselves. And that's all Stand Your Ground says. It's a small part of self-defense. As a matter of fact, to be able to rely upon standing your ground, you have to be, number one, in a place where you have the right to be. Number two, you can't be engaged in a criminal activity. Number three, you must act reasonably in every way. So you're going to have people looking over your shoulder afterwards to determine that you were acting reasonably when you were defending yourself rather than turning and running. And most importantly, you cannot be the person who provoked the use of force. You cannot be the person who provoked the fight. All of those restrictions make it clear that stand your ground makes infinitely good sense. And the Trayvon Martin case was not a stand your ground case. That's what, it's very clear. Had nothing to do with stand your ground. So, this situation where this bill by Senator Bradley deals with the obligation of the state to prove its case. And when that was presented to the Florida Supreme Court this last summer, the Supreme Court, because they didn't have further definition from the legislature, said that in a pretrial hearing, the defendant had the burden of proof by a preponderance of the evidence to show that they were entitled to the immunity. Not just the immunity relating to stand your ground, but the self-defense immunity. And the vast majority of cases that deal with the issue of self-defense don't have anything to do with stand your ground. Because stand your ground is limited to that very small number of cases when somebody has the opportunity to turn and run, but decides to protect themselves and use force to meet force. That's all. And so in self-defense cases, the question was, since the legislature had not given direction to the Florida Supreme Court, to the courts, they had decided that, as in other immunities that relate to status rather than action, that the responsibility should be upon the defendant in a pretrial proceeding. Now, a couple of the justices said that is just simply wrong. They dissented. And they said, no, it should always be the burden of the state to show those kind of things. Because when you are charged by the state with a violation of law and you have the chance of losing your livelihood and possibly your life, that the state should have the responsibility. We've always believed that the state has the responsibility. And so that's what this bill does. It deals with not just stand your ground. And unfortunately, stand your ground has been used as a broad brush to deal with all kinds of self-defense. Self-defense that has nothing to do with that split-second case in which someone is attacked by somebody else. And then, under prior law in Florida, had the obligation to turn and run when their life was at stake, rather than being able to use common sense and potentially, in that split second, stand their ground. That's all. So, I applaud Senator Bradley for what he's done. And by the way, with all the states that have adopted stand your ground, I want everyone to realize that it wasn't a new concept. Florida was in the minority by creating a judicial concept that there was an obligation to turn and run when you were under those circumstances. A majority of the courts across the United States had already adopted stand your ground as a common sense solution to this very, very troublesome problem. Florida had taken this enlightened view, judicially, that a person who had been attacked, whose life was at stake, had to turn and run rather than protect themselves. And so, there's nothing unusual or improper about Senator Bradley's bill. It's good common sense. And you know what? When we walk in this door, we don't need to leave common sense outside. So I support Senator Bradley's good bill, and I hope that you'll support it too.
Senator Thompson in debate.
Thank you, Mr. President. Senator Simmons just laid out the criteria that has to be met with regard to stand your ground. He said that you must be in a place where you have a right to be. That sounds like Trayvon Martin to me. He said that you cannot be involved in criminal activity. That sounds like Trayvon Martin to me. He says that you cannot be the person who provokes a fight. Trayvon Martin turned and ran. So that sounds like Trayvon Martin to me. However, in that particular case, even though had he lived, he would have been able to claim stand your ground, he was vilified as the individual who we were told should have stopped, should have answered the wannabe police officers' questions, that he should not have struggled. Zimmerman talked about the fact that he had a bloody nose when he took himself to a fight. If you're in fear of your life, you don't put yourself in danger. And even when he was told not to follow, he followed. And what we're being asked to do today is to put the burden of proof on the state so that the state now must somehow prove a negative, that there was no threat, that there was no reason to be fearful. And in these cases, you only have one person's side of the story. It's the last man standing. It's the Wild Wild West. Trayvon couldn't tell his side of the story because he was dead. So we only had the version that was presented by the individual who hunted him, who tracked him down, who engaged him in an altercation. And to try to improve what's already a bad law, I think is not the direction that we want to take. And so I object to this bill. I will not be supporting this bill. And I'm saying let's common sense. Let's talk about the person who is affected by this law. People like Trayvon, people like Jordan Davis, and so many other names that we could call in this chamber this afternoon. So let's put the burden back where it belongs. If you go back to the Castle Doctrine, certainly you have a right to defend yourself. You have a right to defend your home. And what Stand Your Ground did was to take it into the streets. You're not defending your home. You're not defending your castle. You can simply take lethal force, deadly force, if you fear that your life is in danger, if you think that a person has a weapon where no weapon is found later on, you can claim stand your ground. And now the state must prove that you were not in fact fearful. So I will not be supporting this bill today. Thank you, Mr. President.
Further in debate? Is there further debate? Senator 31st District, Senator Smith, you recognize in debate.
Thank you, Mr. President. I guess my debate changed a lot this last few minutes after my good friend, the Senator Simmons, got up and gave his rendition of what stand your ground is. And I've done a little bit of work on this over the last couple of years, and I just wanted to clear up a couple of things, and maybe there's disagreement. Just realize, I think the statement was made that self-defense and stand your ground, like there's two different things. Let me explain to you the law in Florida. Self-defense is stand your ground. There is one thing. You can't plead self-defense without stand your ground. And stand your ground was used in the Zimmerman-Martin case. If you don't believe me, look at the judge's ruling. Look at the jury instructions. The jury instructions clearly say, stand your ground. That's not me guessing it. That's me reading it. So whenever you claim self-defense in the state of Florida, you're claiming stand your ground. Now, there's two issues with stand your ground. There's, the no duty to retreat, and then there's the preliminary hearing. Now, the preliminary hearing is what we're really discussing now, and I'll get to that in a minute. But I also have to go back to the knife at the throat. Almost laughable. I've been looking at this for a while, and I've yet to find the case. And trust me, I've gotten emails from everybody around this country, but I've yet to find the case that a woman is in prison because somebody had a knife to her throat and she didn't run away. Not one case. Not one. Because prior to 2005, we had something called self-defense. And I can go down case by case by case. Person at a car wash defended themselves. Person at a pawn store defended themselves. Person in a park defended themselves. If somebody got a knife to your neck, you never had to run, because the word that was in use and the duty to retreat, and which was said so many times, there's one major word that the proponents never talk about, and it's duty to safely retreat. That's a big difference. And people that want to talk about the duty to retreat, they forget that one word, but that is a significant word. The law had always been you had a duty to safely retreat. So if you're in a parking lot and someone got a knife to your neck, you don't have you can't safely retreat. You can always defend yourself. Prior to 2005, prior to any time, you had self-defense. So let's not think that this stand your ground is some panacea and now all of a sudden people can defend themselves. Prior to 2005, plenty of people defended themselves and didn't go to prison. And I still ask for that one case. And people that are watching, Google it. And please send me that one case of a woman that defended herself in a parking lot with a knife to her neck and now she's in prison, because it don't exist. It's a red herring. So let's not think that stand your ground is some panacea. Also, now let me get to this bill. The other part of stand your ground, and the most important part, is that preliminary hearing. Is not this before you even go to trial. There is no trial at this stand your ground hearing that we're discussing. So when you watch Law and Order and all the other things, and you see the defense and the prosecution, and they bring witnesses, and the cops go out and find more stuff, and all these witnesses, this is a preliminary hearing. So you don't even get to that point when we're talking about this bill. This is when you go forth and you say, hey, I was standing my ground, boom. Now the prosecutor, if this bill passes, prosecutor has the burden to come up and disprove that you were standing your ground. And the concern is when you have situations where the case is still ripe, the case is still early, because remember, the defense moves for this. So you kill someone, you get arrested, immediately you say, I want to do stand your ground hearing. I want that preliminary hearing. So the case is still ripe. They haven't gotten all the evidence in. The case is still ripe. And you're shifting the burden to the prosecution for a case that's not yet ripe to disprove something you've said. So that's the concern. We're talking about preliminary hearing, and we're shifting that burden. And the reason we're here is because the Supreme Court looked at our statute and didn't just say, oh, well, we just want to go by legislative intent, as was alluded to. Supreme Court also looked at case law and looked at how we should conduct ourselves as a society and said, you know what, because immunity is so large, because immunity stops a trial, because immunity is so much, we're going to put the burden on we're going to make sure the defense have the burden, because immunity is such, you were stopping a trial. So if you're going to stop a trial, we want you to have the burden. And that's what the Supreme Court said. Now, it was alluded to that, two people on the Supreme Court disagreed, and they wrote the dissent. But when I was in law school, what we call the dissent is what the law is not. So I'm not here to quote a dissent. The courts looked at how we should conduct ourselves as a society, looked at other jurisdictions, looked at other cases and said, because this is immunity, because you're avoiding going to trial, because you're skipping everything, you're getting immunity, the least you can do is have to put on some evidence of it. Voting for this would be to say, you don't have to put on that evidence, that the state in a fresh case where they're still investigating, you immediately file this motion. The state has to disprove what you've said. And I think we're going to get some problems where you're going to have situations where cases are decided, people get this immunity, later facts come out, later things come out, and then we're going to be concerned that, oh my God, why did we allow this? So we're talking about a preliminary hearing. We're talking about shifting that burden after justices, Supreme Court justices looked at it and really thought about it and said, you know what, the burden should be here. But we want to react as a legislature and overrule what they said and put in our thoughts, and which we do every day. Trust me, we do a lot of that here. But in this case, I think we're overstepping. If you're going to avoid a trial, if you're going to not be tried, you should at least have to put on evidence. You should have to at least explain why you're not even going to be tried when there's an incident. So we're talking about a preliminary hearing, and we're talking about a major shift in the law. I think we're stepping too far on this. And again, you can always defend yourself. There are states without stand your ground, and people use self-defense. And I can go case by case by case prior to 2005 where people defended themselves, where people were accosted and they defended themselves outside everywhere. And to assume that prior to 2005, prior to stand your ground, that you had to stick around and get your throat slashed because you could have run away, that's disingenuous. You could always defend yourself with stand your ground, without stand your ground. But I think this burden shift will be a mistake. And I ask that you can still have stand your ground, but we shouldn't do this burden shift. If you're going to avoid trial, if you're going to avoid everything, you should at least have to put on evidence to prove why you should avoid trial. Thank you.
Senator of the 7th District, Senator Bradley, you recognize to close.
All right. Thank you, Mr. President. I want to begin by something that all 40 of us can absolutely agree upon, and that is the fact that the tragic deaths of Trayvon Martin and Jordan Davis, they were unimaginably awful for them and their families. They were absolute tragedies. As the parent of 3 teenagers myself, I cannot imagine what Trayvon and Jordan's parents are going through even today, years after those deaths occurred. Let's talk about, from my viewpoint, what this bill is about and what it's not about. This is a procedural bill. This is about, as my good friend Senator Smith suggested, the pretrial immunity hearing. Not the trial itself, but the pretrial immunity hearing. In both the Martin and the Davis cases, neither of those defendants invoked a pretrial immunity hearing. The outcomes would not have been different in those 2 cases, whether this law passes or not. And I think it's simply incorrect to suggest that this bill would result in otherwise guilty individuals somehow going free because this becomes the law. If the state has sufficient evidence to successfully prosecute a defendant at a jury trial, the state will prevail in the immunity hearing before a judge, and the judge will permit the case to go to trial. There was recently a case, the Florida Supreme Court decided the Bretherick case. They have a job to do, the Supreme Court. If they find ambiguity in a law, they can consider legislative intent and decide how to proceed. We have a job to do as well. Our job, and there's no better indicator of legislative intent than the legislature. And if the legislature reviews a decision of the Florida Supreme Court and determines that they incorrectly and incorrectly interpreted legislative intent, that they misinterpreted legislative intent. That is absolutely proper and the right thing to do to fix it. And in this case, in 2005, this immunity was created. Two of the justices on the Supreme Court, I think very rightfully, the two conservative justices, Justices Polston and Kennedy, correctly interpreted legislative intent to be that in the pretrial immunity hearing, the burden should be with the party where it should always be. One thing that I thought the left and right on the political spectrum always agreed upon is the concept that you're innocent until proven guilty. And it is a fundamental tenet of our criminal justice system that the state has the burden of proof in a criminal prosecution from beginning to end. So I simply suggest that we're getting it right today, that the dissent was correct, and we are going to bring full meaning and effect to the 2005 law that was passed dealing with justifiable use of force. I urge your support of this bill. Thank you.
Senator Bradley, having closed on the bill, the Secretary unlock the board members, proceed to vote. Have all members voted? Have all members voted? Lock the board, announce the vote.
24 yeas, 12 nays, Mr. President.
By your vote, the bill passes. Take and read the next bill.